Come to order, and thank you very much. It's now 5 o'clock, and so we are right on time. Colonel?
I'm very impressed.
What time is it?
5 o'clock.
5 o'clock.
1700.
There you go. Thank you very much. Before we get started, I want to send a few thoughts and prayers from the Rules Committee. Each of us saw what happened over the weekend. We're aware of the terrorist attacks in Paris. That was an attack on all of us. When America was attacked on 9/11, we asked our friends around the world to stand up with us. I'm sure that we will stand up with the people of France and free people. There were some Americans that were killed. Our thoughts and prayers go out for them also. Tonight, the Rules Committee will consider two bills, H.R. 511, the Tribal Labor Sovereignty Act of 2015, and H.R. 1737, the Reforming the CFPB Indirect Auto Financing Guidance Act of 2015. H.R. 511 is designed to protect tribal sovereignty from NLRB overreach and to ensure that tribes are not treated differently than other sovereignties under the National Labor Relations Act. H.R. 1737 would repeal the CFPB's faulty guidance on the auto industry and will provide consumers with the opportunity to receive the best financing available so they can buy a car. This bipartisan act has 166 co-sponsors, including 65 of our Democrat colleagues. Before us today is the young chairman of the Labor and Education and Labor Committee from Minnesota, the gentleman. Education workforce. Education in the workforce. You know, he just smiled at me, Bobby. Oh, is that what it was? It was a long time, so much so I memorized it. It was a long time. I am serious also. We did change the name. And also my dear friend who's here to help correct me whenever I need help. And Bobby, thank you very much. You've done that for years. The gentleman, Bobby Scott of Virginia. Chairman, you know how many more times than not you've been before the Rules Committee, and I know that you've announced your retirement, but that's not for another year. So as the old saying goes, beatings will continue until morale improves. You're here before the Rules Committee again today, and I must say you have a lot of friends that are up in this committee, and we enjoy it when you bring Mr. Scott with you. Before we move forward to our panel, I'd like to go, if I can, defer to the gentleman, member of the Rules Committee, the ranking member tonight, the gentleman, Judge Hastings. Judge, you're recognized.
Thank you very much, Mr. Chairman. Mr. Chairman, I echo your sentiments regarding the horrible tragedy over the weekend in France, and hopefully we stand alert here in our country to the possibility of those things happening. On a happier note, Mr. Chairman, I'd just like to place into the record that Debbie Delaney did. She and her husband have their baby, and his name's Sam.
Sam.
So Sam is in the house.
That's great. That's awesome. You know, one more happy Rules Committee family member. You know, Judge Hastings, we have our friends from the tribal community here today, and we're delighted to see them. I notice lots of smiling faces here, and I know that what we're going to do is get to that in a minute. But first, we have two of our witnesses, and we're delighted that they're here. So without objection, anything you have ready will be under the record, and I know both of you have come ready and prepared not only to speak properly, but leave what's left for our awesome stenographer. With that said, the gentleman, chairman of the committee, is recognized.
Thank you, Mr. Chairman. I want to thank you and tonight's ranking member, Mr. Hastings, both for your comments about the horrific slaughter that took place in Paris, and our prayers with our friends in France. Mr. Chairman, tonight I'm here along with Mr. Scott to talk about H.R. 511, the Tribal Labor Sovereignty Act. You know, for decades, and more than that, our laws and courts have established and held that sovereign Native American tribes have the right to self-govern, and that's what this is about. Policymakers have agreed on the importance of protecting that right. Unfortunately, for the past 10 years, the National Labor Relations Board has adopted a different view. In 2004, the NLRB overturned longstanding precedent and ruled that it has jurisdiction over tribal activities. Since then, the board has decided on a case-by-case basis when and where to assert its jurisdiction over tribal businesses. This subjective approach of picking winners and losers among tribes has been met with significant opposition. Tribal leaders say the board's actions are aggressive, unproductive, and, quote, an affront to Indian country. We have a responsibility to right this wrong. That's what this bill does. This is a bipartisan bill. It's been a long time coming, as my friend Mr. Cole indicated, when we were freshmen. We got here and this bill came up because that was the first time that we had seen this drastic change. And now we're at a point where with bipartisan support, I think we have a real opportunity to pass this bill in the House, focused on tribal sovereignty, and in the Senate, and have a chance to finally correct this wrong. So with the chairman's permission, I will submit my written comments for the record, and I'm ready to answer questions. I yield back.
Thank you very much, Mr. Chairman. Mr. Scott, welcome to the Rules Committee. We're delighted that Chair and gentleman's recognized.
Thank you, Mr. Chairman, and Ranking Member Hastings, members of the committee. I understand the purpose of this meeting is to adopt a closed rule on H.R. 511. The legislation would strip employees of protections afforded under the National Labor Relations Act at any enterprise owned and operated by an Indian tribe and located on Indian-owned land. At issue, this bill's two solemn and deeply rooted principles. One is the right of Indian tribes that they possess as distinct independent political communities, retaining their original natural rights in matters of local self-government, and the rights of workers to organize, bargain collectively, engage in concerted activities for mutual aid and protection. Rather than attempting to reconcile these competing principles, H.R. 511 chooses sovereignty for some over long-standing rights of others. This bill strips hundreds of thousands of workers of their right and their voice in tribally owned workplaces such as casinos, hotels, and mines. It should be noted that of some 600,000 workers employed by tribal casinos, 75% are not members of tribes. Excuse me. This legislation would jettison the carefully drawn balance between the tribal sovereignty and workers' rights that was adopted in a 2004 decision issued by a Republican-led NLRB. That decision, the San Manuel Indian Bingo and Casino case, restricted the jurisdiction of the NLRA if it touches on the exclusive rights of self-governance in a purely intramural matter or abrogates rights guaranteed by treaties. Moreover, the NLRB stated that it would take into account and accommodate the unique status of Indians in our society and the legal culture in deciding NLRB jurisdiction. That decision has been upheld in every appeals court where it's been challenged and is based on legal precepts governing laws of general application, which, with respect to tribes, that have been upheld by the majority of the appeals courts over the last 30 years. Courts have found that tribal casinos are commercial enterprises serving predominantly non-tribal clients and hiring predominantly non-tribal members to operate them. The bill also sets up a double standard. The International Labor Organization, which the United States is obligated to as a government to respect and promote the rights outlined under the ILO Declaration of Fundamental Principles and Rights at Work, including the freedom of association and effective recognition of the right to collectively bargain. Democrats and Republicans have insisted on our trading partners abiding with and enforcing basic labor rights, and Congress has repeatedly ratified these obligations in trade agreements. Mr. Chairman, I have a much longer statement, which I'll just, at this point, introduce into the record.
Most appreciated. Thank you.
But I would want to introduce for the record a letter from the International Labor Office, which outlines the problems with this bill in terms of our international obligations. And I'm ready for questions.
Thank you very much. Gentlemen, thank you for being here. Mr. Chairman, I have attempted to the best of my really thoughtful agreement with myself. I've understood many issues that tribal interest involve in water rights, business interest, and other things that tribes have attempted to gain a footing on in this country. And I recognize their sovereignty. I believe the federal government has dealt with tribes sometimes poorly, sometimes well over our history. Certainly, the gentleman Tom Cole from Oklahoma, as a friend of mine, has spoken with me a number of times about these important issues. But to the best of my knowledge, the NLRB jurisdiction over Indian tribes really held for some 30 years, I think, two doctrines. One, that individual Indians and tribal governments on reservations' land should be free from state or even most federal intervention unless Congress specifically got involved in that. And I recognize it's a double-edged sword. Sometimes things are very much and necessarily in the sovereignty issue, and sometimes there needs to be work on it. But under this issue of the NLRB, I do agree that for these years, that where they're dealt with an on Indian lands rule, that the NLRB should not be involved. That's the essence of this, isn't it? Where it's on their own, within their own sovereignty, within their own lands, that they should be able to make their own decisions. Is that correct?
That is correct, Mr. Chairman. You look at the history, as you said, it has been back and forth at best. Some of our colleagues might say it was more back than forth. But you have a constitutional issue, a recognition of tribal sovereignty. You have treaties that turn out to be totally binding and have to be recognized. But as we know, we have a history of having broken those treaties. But it comes down to this. Either these tribes are sovereign nations or they're not. And why should they have less sovereignty than a community, a county board, or something like that? So this is narrowly focused. This is just about tribal sovereignty and making sure that the tribes keep that sovereignty on their land.
I agree. And this is something, and I know we could debate a number of issues that I've talked with the tribes over years about, including lawsuits and agreements that do go back to really treaties and laws between nations, in this case, tribal nations and the American government. Well, I'm delighted that you're here. I agree with you. I'm a co-sponsor of the bill. But more importantly, I think I'm delighted that you're here and have taken time to do this. Mr. Scott, I appreciate you taking time to be here also. And I will read specifically the things that you brought up here today, even when I disagree with them, and I thank you very much for that. Mrs. Fox.
Thank you, Mr. Chairman. I want to thank my colleagues from the Education and Workforce Committee for being here today, and echo your comments about appreciation of the chairman. I am going to say only thank you, and I yield back so that my colleague over here can have whatever time he might need from me to ask questions or make comments. Thank you very much.
Joe Woman yields back your time. Thank you very much. Judge Hastings, you seek time.
Yes, I do.
Gentleman's recognized.
Mr. Chairman, thank you, and I thank Chairman Klein and Ranking Member Scott very much. I know that they have given thoughtful consideration to this matter. Mr. Chairman, I don't want to cloud the record, but I do believe it helpful to reflect on the divergent views with reference to this matter. Toward that end, I would appreciate an opportunity to offer and ask consideration of several union workers. One at Foxwoods, very celebrated place where I've had an opportunity to visit on a couple of occasions. But this one is from the UAW, and I ask unanimous consent to allow it to be placed in the record. Mr. Chairman?
Without objection.
Okay. Additionally, I'll combine these two, and Unite Here is in opposition.
Without objection.
And American Federation of Labor and
Without
the
objection.
Congress of Industrial Organizations, the United States Steel Workers Union.
Without objection.
The International Brotherhood of Teamsters.
Without objection.
All oppose our sovereignty, and a bold voice for transportation workers.
Without objection.
as well.
Yes, sir.
Mr. Chairman, many times in this committee, I've had the privilege and the opportunity to discuss my relationship with the Native American community, specifically the Seminole Tribe of Florida and the Miccosukee Indians that I have had over the years a strong interface with, both as a judge ruling favorably for the Seminole Tribe to undertake bingo operations many years ago, which led to many opportunities that flowed from that decision. I wish to do justice to this because it is a major conflict for many of us that have similar concerns for both sides of this issue, but I do want to include the Seminole Tribe of Florida Chairman of the Tribal Council, James Billy's letter in support of this legislation and lift from it, with your permission, Mr. Chairman.
Without objection.
His comments that enacted in 1935, the NLRB Act defines the term employer to include any person acting as an agent of an employer, directly or indirectly, but shall not include the United States or any wholly owned government corporation or any state or political subdivision thereof. For nearly 70 years, the NLRB included federally recognized Indian tribes within the government's exemption. And then he goes on to say, however, on May 28, 2004, the board in San Manuel Indian Bingo and Casino ignored its own established precedent to apply the NLRA to on-reservation tribal government enterprises. I could go on, but I want his letter in the record for the reason that I want to point the conflict that I have and certain members have, and how difficult it is for us to come to this decision. So I ask unanimous consent to include that letter.
With that objection, that's been
Also,
granted.
on the side of support the National Congress of American Indians, I received a comment from them, Brian Cladd-Dusby, who is their president, and their recording secretary also is a signatory to their letter, and I'd ask unanimous
Without
consent
objection.
for it to be entered to the record. And of course, the Chamber of Commerce, who I support a lot, but don't support me much. The Chamber of Commerce has also submitted a letter in support, and I'd like the one that I received from R. Bruce Johnston to be made a part of the record as well, Mr. Chairman.
Without objection.
Also, Mr. Chairman, finally, I'd like to lift from the minority views over the signature of the ranking member Scott and several other members. I won't mention their name, but I do think it's necessary to put into the record and to say now how I feel with reference to this legislation. What the minority views say, and it's very succinct, this legislation is not needed because the NLRB's case-by-case approach balances two competing principles: protection of workers' rights and the preservation of tribal sovereignty. The bill's all-or-nothing approach is too sweeping, and there is no principal basis for excluding hundreds of thousands of workers from coverage under labor laws just because they happen to work in a commercial enterprise on tribal lands. This bill cloaks an anti-union agenda in the respectable garb of tribal sovereignty. It is another attempt in the majority's quest to dismantle labor unions and strip workers of their ability to bargain for better pay and working conditions. We urge the full House of Representatives to reject this legislation, and I ask unanimous consent that that be placed into the record.
Without
Mr.
objection.
Chairman. Thank you, Mr. Chairman. That's all I have.
Gentleman yields back his time. Thank you very much. Mr. Cole.
Thank you, Mr. Chairman.
Yes, sir.
I want to begin by congratulating my good friend, Chairman Klein, on getting this legislation to this point, and hopefully soon onto the floor. I know how supportive you've been of this and how hard you've worked on it over the years, and very, very grateful for it. I suppose I approach this as a consistent advocate of tribal sovereignty. And as my friends on the other side of the aisle know, sometimes that puts me with them, and I think of the Violence Against Women Act. I was for it anyway, but the tribal sovereignty provision was decisive for me. And so I worked with Democratic friends to see that that was passed and placed on the president's desk, and he signed it. This is, and I recognize my good friend from Florida's dilemma here. It is difficult. It does put some competing principles. But for me, tribal sovereignty is always supreme in this matter. And so I'm delighted to work with my Republican and some of my Democratic friends to make sure that we expand tribal sovereignty yet again and really reclaim what was lost. Let me ask both of you this question. Does the NLRB have jurisdiction over any other government's employees?
Not that I know. The gentleman from Florida pointed out from the very beginning that it wouldn't apply to any state or political division thereof, but somehow that escaped the Indian tribes. And if I could, if the gentleman would bear with me for just a minute, my friend from Florida pointed out that we don't need this because the NLRB is deciding case by case where there's sovereignty. And I find that to be very, very troubling. I'll tell my friend from Florida, sovereignty isn't case by case, it's determined by a bureau. Whether it's 5 members or 20 members, there is sovereignty or there is not. And so I think that underscores the problem, if I might say, to my friend from Florida. There should not be a case by case issue here. I'm sorry, you back.
Well, it is a case, it's law by law, because nobody's suggesting that the Fair Labor Standards Act doesn't apply. Nobody's saying that OSHA shouldn't apply. Nobody's saying that the Employee Retirement Income Security Act, ERISA, shouldn't comply. Nobody's saying that Social Security Act shouldn't apply. Unemployment compensation being withheld. There are a lot of bills. Criminal law applies. You don't have sovereignty.
If I may, though, that wasn't my question.
I know. I'm getting-
Does the NLRB have jurisdiction over other government employees, state employees, county employees, municipal employees?
Post office, but in terms of states have within their laws, virtually all states, unfortunately Virginia is not one of them, but virtually all states have a provision for employees to be able to organize. And if the bill included an alternative mechanism, then we wouldn't be having the dispute we have now.
That's not my question. And my question is, does the NLRB have jurisdiction over any other governmental employees? And the answer is no, it doesn't.
Well, those employees have rights under other laws.
That's not my question. My question, and is there anything in the original legislation that created the NLRB where it had jurisdiction over Indian tribes?
Well, it had jurisdiction over everybody else, the Indian tribes.
No, it doesn't. It doesn't have any jurisdiction over federal employees whatsoever. It doesn't have any jurisdiction over the employees of the state of Oklahoma or the state of Virginia or the state of Alabama or the state of New York or the state of California. It doesn't have any jurisdiction over county employees. I mean, does the original legislation give it, that Congress wrote and passed, give the NLRB jurisdiction in this area?
The problem with this is that when you say Indian lands, that does not mean on the reservation, that means Indian-owned. So you can have a casino in downtown Las Vegas, happens to be owned by a tribe, and all of a sudden, those people
We'll get to the kind of thing, but
today have rights to organize.
Not my question. My question, again, did the original legislation give the NLRB any jurisdiction over Indian tribes? And I think if you go back and check, it did not. Was there any other subsequent act of Congress that gave the NLRB jurisdiction over Indian tribes?
Well, there are a lot of laws that are silent that the laws apply. And if it was silent, the law can apply or not, depending on what the interpretation of the courts are.
Again, I don't mean to be belligerent, but I'm just asking,
Okay.
do you know, well, I can tell you, no. So the NLRB claimed this jurisdiction on its own in 2004. It didn't come and ask Congress. It wasn't given this title, and for decades it operated without the idea that it had jurisdiction here. It just decided on its own, bureaucratically, in 2004, that it would do this. And it did so, and in doing so, it developed an artificial distinction between tribal employees. It said it did not have jurisdiction over, quote, governmental functions, but it did have over commercial activities. We've got lots of states involved in commercial activities. State of Virginia runs the liquor stores. We have plenty of park services that run hotels, that do all sorts of things, but the NLRB still doesn't have jurisdiction in those areas. And so this is a case really of a bureaucracy taking jurisdiction, in my view, on its own. And without any act of Congress deciding its power would go. The other principal thing here that's important to recognize is that, you know, these are sovereign entities that don't have the power to tax. In other words, we've limited their sovereignty in that way. So this is their governmental income. And, you know, it should be up to them to run their own labor affairs. And this is, you know, significantly supports their governmental functions, their services to their own tribes. But bottom line is, again, there's just simply no congressional action that gives the NLRB this kind of authority. Never has been.
Well, the one problem is that most of the people that work in these operations are not members of the tribe. If it was just a on-the-reservation situation where the members of the reservation were working, you wouldn't have this problem. The problem is you're downtown Las Vegas, 75% or more of the people working there have nothing to do with the tribe. It's just a commercial
I
operation.
don't think there's any tribal facilities in downtown Las Vegas, but, you know, I get your point, but that's, you know, that's a free choice as to whether you work there. The NLRB doesn't have any jurisdiction if you work in the federal government either. That's my choice. I choose to work for the federal government, but the NLRB doesn't get to all of a sudden claim, you know, authority there. This is a governmental entity. These are governmental employees. And for the entire history of the board, until 2004, which is about 70-odd years, it never claimed that authority previously. So anyway, this seems to me a straightforward thing. You're either for tribal sovereignty or you're not. They either get to run their affairs or they don't. I thought it was appropriate for them to have jurisdiction on their own land. And the Violence Against Women Act, somebody came on that was non-native and committed a crime on their territory, that their courts and their law enforcement should have jurisdiction. And that was the position of the administration too, by the way, and I thought it was the right thing to do. I think this is the right thing to do for exactly the same reason. The sad and long history of this has been the erosion of tribal sovereignty on their own lands over their own activities. And this is a case where a federal agency, without congressional authorization, decided on its own that it would just assume jurisdiction. Didn't go ask the Indian tribes if they wanted to have this jurisdiction. Didn't come ask Congress to have this authority, even though it wasn't. It just decided on its own it would assert authority. And I think this is an effort to correct that. And if Congress wanted to do something legislatively, I suppose they could. And then that would raise the question, do we want to extend the NLRB's jurisdiction over federal employees and state employees and local employees? But in this case, this is one where a federal bureaucracy on its own decided it would just take jurisdiction over something it had not had jurisdiction before and Congress had not granted it. So I appreciate, Mr. Klein, your effort and Mr. Akita's effort. I know this is his bill. I know how hard he's worked on it. And interesting to note, he's not from a state that has any Indian tribes there, but I'm really proud. Yeah, in Indiana, that's another story about how we get to a state in America that there's no Indian tribes in a place called Indiana, but that takes us to a sad chapter of our history I won't go into here. But I do appreciate his efforts a great deal, and I appreciate your efforts and the efforts of your committee, and I appreciate the fact that it's bipartisan as well, because I know we have many Democratic friends. But I also want to join my friend in Florida, and I do recognize that this is difficult. You know, in some ways, those of us on this side of the aisle, violence against women, tribal position, it wasn't difficult for me, but it was for some of my colleagues. And I understood because they saw fundamental values in conflict in terms of constitutional guarantees and what I understand all that. But at the end of the day, if tribes are going to be sovereign, they need to be sovereign, to your point, Mr. Chairman, and this legislation clarifies that in a very important area. So I thank you for bringing it. Without a yield back.
Governor yields back his time. Thank you very much. Mrs. Slaughter?
Oh, thank you, Mr. Chairman, but I arrived late, and as punishment for myself, I will not ask a question. And I'll do better next
I love this punishment up here. It's a good thing.
It's southern.
You got home, got your hair done too. I like that. Saw you in the hall earlier.
They wouldn't let me out of town.
Is that
so
right?
I did it. Yeah, delegation met me at the airport.
Well, you look great. Told you to stay.
Something's gotta be done here.
Yes, ma'am. Yes, ma'am. Dr. Burgess, do you seek time? Dan, you got a special guest.
Would the chairman recognize me?
The gentleman, I'll recognize Carol if you want me to, but I'm going to let you do that job.
Well, gosh. Well, I'm happy to have with me today the most important person other than this committee in my life, my young wife. Thank you, Mr. Chairman, for that. Carol's here with me this week, and I just want to introduce her to everyone.
Carol, welcome. We're delighted that you're here. You know, we hear the stories Dan talks about. If he gets home and instead of being told to take the trash out, go to work, that you've been working during the entire week, so he just can't wait to get home every weekend. Yeah, or something like that. Mr. Polis, do you seek time? Yes, gentleman's recognized.
I just wanted to go to Mr. Scott, and of course, we had the opportunity in committee to look at this bill as well. And I think one thing that's important to talk about is, I know, Mr. Scott, when we had our hearing in the committee, didn't we have a Native American very strongly opposed to this bill who felt that it was actually taking rights away from Native American workers?
If you lose your rights to organize and protections under the NLRA, you just lose the rights, and if the bill passes, that's exactly what would happen. And again, you're just talking about labor rights. You're not talking about OSHA. You're not talking about RISA. You're not talking about fair labor standards. Just pick this one out of the mix.
And out of all the things...
And also, if you're talking about equality with states, you're also not talking about sticking the Title VII of the Civil Rights Act covering that.
And many of the people that work under the tribes are Native American as well. Some are, some aren't, and this affects the rights of those Native Americans. I would also point out that a lot of these tribes as nations are owners in what you or all might call businesses, Mr. Chairman. They actually run businesses for revenue, and they look a lot more like, and in fact compete against traditional corporations that are their competition, that are, of course, subject to these laws. So I think, in our committee, I wanted to be clear that one of the witnesses that was against this bill was representing the sentiment of many Native Americans who also feel that their rights as workers should not be sacrificed simply because they happen to be working for a business with which a tribe is involved. Now, of course, I'm also a strong supporter of tribal sovereignty, which is a critical issue. But the right to organize and protect our workers should certainly include Native American workers in fighting for a safe and fair working environment. And I think balancing the right to sovereignty with the protections due to all Americans in all of our states and all of our tribal lands, regardless of their race, ethnicity, cultural practices, or governing structure, is absolutely critical. And I hope that in the future we can do a more thoughtful job of balancing those rather than taking a particular concern and we're trying to resolve it in a way that benefits economically tribal businesses at the expense of many tribe members who might work for those businesses. And I'll yield back.
Gentleman yields back his time. I want to thank both of you for being here. I think there are always important issues that come before this committee, and some that really need to be debated that we really can't completely get our arms around. This is a sovereignty issue. This is an issue that deals with on tribal lands for tribal people to make their decisions. And I really do view where the tribe should be able to, as they choose, if they want to participate in Social Security or anything else, they should have that opportunity if they choose to. But likewise, something shouldn't be put off on them that they choose not to. And I think that's exactly what this is. And the 30 years plus of NLRB rulings, I think is indicative of that. Yes, sir. Without objection, we'll enter that. And once again, Mr. Scott, I would encourage you and Chairman Klein, anything that you have that you brought here that you wouldn't want included in the record, without objection, we'll include that. I want to thank both of you for taking time. And as always, thank you for your time to be here today very much. Thank you very much. Thank you, yes, sir. Okay, we've now heard on the Committee on Education and the Workforce. We'll now move to H.R. 1737. We welcome the gentleman, the chairman of the Committee on Financial Services, gentleman from Dallas, Texas, and his ranking member, the gentlewoman from Los Angeles, California, Maxine Waters. I want to welcome both of you. This seems to be a regular occurrence. I appreciate both of you taking time to be before the Rules Committee. I think the gentlewoman, Ms. Waters, and the gentleman, Mr. Henschling, knows that we look forward to you coming up, to your energy, to your excellence in presentation, and most certainly because of the ideas that you represent. Without objection, anything you haven't read will be entered the record. And I want to thank you. Just so you know, we have a colleague, Dan Newhouse, has his wife Carol over to your right. She is a farmer from the state of Washington. She does the work, Mr. Chairman, I will tell you, just as when you get home and told the work that got done during the week, now haul to it, she does the same thing to Dan, and so we're delighted to have her as our special guest tonight. Mr. Chairman, without objection, anything you have right within the record, and gentlemen is recognized.
Thank you, Chairman Sessions and Ranking Member Slaughter, members of the Rules Committee. I appreciate the opportunity to testify before you on H.R. 1737, the Reforming CFPB Indirect Auto Financing Guidance Act. This bill was approved by the Financial Services Committee with strong bipartisan support, including the support of between half and two-thirds of the committee's Democratic members who voted. Introduced by our colleague from New Hampshire, Mr. Ginta, and co-sponsored by 166 bipartisan members of the House, H.R. 1737 repeals the Consumer Financial Protection Bureau's flawed bulletin on indirect auto lending and compliance with the Equal Credit Opportunity Act, which was published on March 21st, 2013. The bill also requires the CFPB to follow a transparent process when issuing any subsequent auto finance guidelines. In fact, the bill is quite simple. It requires any future guidance of the Bureau to, number one, provide notice and an opportunity for public comment. In other words, due process. Number two, make any studies, data, and analysis used in the writing of the bulletin public. In other words, transparency. Number three, to consult with other relevant regulators. And number four, to actually study the impact of the guidance on consumers as well as women-owned businesses, minority-owned businesses, and small businesses. The CFPB's bulletin tries to regulate compensation paid to auto dealers who are specifically exempt from the CFPB's rulemaking or enforcement authority under the Dodd-Frank Act. In issuing this bulletin, the Bureau went far beyond simply restating the law, which is the purpose of a bulletin, and did so without formal rulemaking or public input. Thus, this bulletin represents not just an end-around run around the Dodd-Frank Act, but also the Administrative Procedure Act. If Congress means what it says when we write the law, then the CFPB cannot be allowed to willfully ignore the law. The concerns of this bulletin are not partisan, nor are they limited to the House. More than 90 members of the House and Senate, both Democrats and Republicans, have sent 13 different letters to the CFPB asking questions about the methodology the CFPB employed to determine whether fair lending violations exist in the vehicle finance market. These letters also express serious concerns regarding the CFPB's bulletin. Yet it took nearly a year and constant pressure from members on both sides of the aisle before the CFPB was responsive and provided documentation regarding its disparate impact methodology. In the white paper ultimately provided by the CFPB, the Bureau admitted that its proxy methodology for determining racial disparities is flawed and overstates the number of African Americans by 20%. However, outside statisticians at the well-respected Charles River Associates found that this figure could be off by as much as 41%. which points to a major flaw and calls into question the reliability of any CFPB's findings relating to alleged discrimination in the auto finance market. Not only does it call into question the reliability of the CFPB's attempts to police the fairness of auto loans, its preferred outcomes will increase cost for consumers. The CFPB has pressured finance companies to lower caps they set on dealer reserve or to eliminate dealer discretion altogether, which can be a percentage of the loan or set amount. However, under this pricing model, the Wall Street Journal found that interest payments for some consumers could increase by as much as $586 over the life of the loans. In other words, the guidance is probably decisively anti-consumer. Some argued during committee markup that this bill is somehow an attempt to handcuff the CFPB or prevent it from performing its important anti-discrimination efforts. To those critics, I say read the bill. It is quite short, roughly a page and a half of textual material. Repealing flawed guidance does not necessarily prevent the CFPB from bringing actions to enforce the Equal Credit Opportunity Act. We are not repealing the law. We are not touching the underlying statute. With this bipartisan bill, we are simply telling the CFPB that it cannot attempt to change industry practices in the guise of guidance and must provide opportunity for public comment. I suspect that the end result of this bill will be that the CFPB will simply refuse to offer new guidance. The bill doesn't force the CFPB to offer new guidance. It is the CFPB's choice or discretion, but it would be a shame if the Bureau did not reissue the guidance because this bill creates an opportunity for the CFPB to live up to its claims of transparency and accountability. Because this bill is a common sense solution that doesn't infringe on the ability of the Bureau to do its job, H.R. 1737 has earned the support, again, of Republicans and Democrats. 166 members from both sides of the aisle are co-sponsors of this bill, including Mr. Perlmutter of Colorado, Ms. Beatty of Ohio, Ms. Maloney of New York, Mr. Kildee of Michigan, Mr. Scott of Georgia, and Mr. Sherman of California, all Democrats on the Financial Services Committee, as well as Mr. Hastings of this committee. H.R. 1737 is such a bipartisan and common sense bill that it was approved by the Financial Services Committee with the votes of 47 of the 57 members who voted. That is 82%. It should probably be on the suspension calendar. Nonetheless, I appreciate the opportunity to testify before you today. Hope we can work together so the CFPB can reissue new guidance in a more transparent and accountable process. As always, Mr. Chairman, I'm happy to answer the committee's questions.
Thank you very much, Mr. Chairman and Ranking Member Slaughter and committee members for allowing me to testify today on H.R. 1737, the Reform in CFPB Indirect Auto Lending Financing Guidance Act. This bill amounts to a vote of no confidence in the CFPB and its enforcement of federal fair lending laws, even though the market for auto loans is still rife with discrimination, with racial and ethnic minority borrowers receiving markups that have nothing to do with their credit worthiness. Specifically, H.R. 1737 would nullify the CFPB's March 21st, 2013 guidance and require that any future guidance on indirect auto lending be subject to a notice and comment period similar to those required for rulemakings under the Administrative Procedures Act, as well as a requirement that the CFPB consult with other federal regulators and conduct a cost-benefit analysis on the impact of the guidance on small and diverse businesses. As an initial matter, no other regulator is required to undergo notice and comment and to conduct a cost-benefit analysis in order to issue guidance to its regulated entities. There's no compelling policy rationale for any of H.R. 1737's restrictions, as the guidance from the CFPB is just that, guidance, designed to assist auto lenders comply with the federal law. For 3 years, lenders have used this guidance to develop compliance policies. Canceling this guidance while also imposing burdensome restrictions to delay or prevent any future guidance, just as DOJ and CFPB scrutiny intensifies, is harmful to lenders and consumers, and introduces uncertainty for lenders seeking to follow the law. To be clear, the guidance at issue is only 5 pages and simply explains the CFPB's jurisdiction over indirect auto lenders under federal fair lending laws, describes lenders' liability stemming from discretionary dealer markup policies, and recommends steps that lenders can take to limit their fair lending risk. Much of the controversy surrounding the guidance, however, stems from the following sentence, and I quote, may include but are not limited to imposing controls on dealer markup and compensation policies or otherwise revising dealer markup compensation policies, and also monitoring and addressing the effects of those policies in the manner described below, so as to address unexplained pricing disparities on prohibited basis or eliminating dealer discretion to mark up buy rates and fairly compensating dealers using another mechanism such as a flat fee per transaction that does not result in discrimination. Auto dealers and their trade associations, with the notable exception of the National Association of Minority Auto Dealers, which opposes H.R. 1737, have all interpreted this provision to somehow mean that the CFPB has a preference for flat-fee compensation and that the guidance establishes a legal standard for complying with federal fair lending laws. As the text of the guidance makes clear, nothing could be further from the truth. Make no mistake, H.R. 1737 is not simply about guidance. It's about tying the Bureau's hands so that they do not issue future guidance and signaling to the CFPB that auto dealers take issue with the CFPB's work to date in reining in discriminatory auto lending practices. H.R. 1737 supporters have been vocal in their support of this proposal, despite substantial evidence that minority borrowers are often victims of the dealer markup practices that have been the focus of 3 recent consent orders and several other ongoing investigations of auto lenders for potentially discriminatory lending practices. In the past year, the CFPB has secured over $140 million in relief to consumers and in penalties against auto lenders who underwrote loans where African American, Hispanic, and Asian borrowers paid more than similarly situated white borrowers, even after controlling for their credit worthiness. The CFPB's enforcement of federal fair lending laws has rightly caused auto lenders to revisit their lending practices to ensure that they do not provide otherwise credit-worthy minority borrowers with more expensive auto loans than they qualify for. Indeed, much of the debate surrounding H.R. 1737 is not about this guidance. Instead, it's about calling into question the CFPB's ability to regulate auto loans at all under federal fair lending laws, despite the CFPB's clear authority to do so in Dodd-Frank. Some of my colleagues will also use H.R. 1737 as an opportunity to again attack the CFPB's methodology for identifying harmed customers, even though the proxy methodology used by the CFPB has been used by the Department of Justice in its fair lending enforcement action for years. Meanwhile, some of my colleagues oppose a requirement for lenders to collect demographic data like lenders must do for mortgage loans, something that would eliminate the need for the CFPB to use proxies. Let me also say that CFPB's oversight over indirect auto lenders has not led to increases in borrowing costs, nor has it led to any restrictions in access to auto credit. To the contrary, the auto lending market is as robust as it has ever been, with outstanding auto loans reaching the $1 trillion mark for the first time ever in the second quarter of 2015. In fact, the industry is likely to reach a record 17 million units sold by the end of the year. In summary, the March 2013 guidance establishes the foundation for the CFPB's work in regulating auto lenders, and H.R. 1737 seeks to remove this foundation and to impose unreasonable and burdensome restrictions on the Bureau's ability to inform lenders of how it can follow federal fair lending laws. So, Mr. Chairman and members, I thank you for the opportunity to testify. I have to tell you, I really do dislike the fact that I have to do this kind of work. There's a lot of work to be done in public policy, but to continue to have to challenge efforts that discriminate against minorities is burdensome. I have been involved, as you know, with the subprime meltdown and the crisis that we went through starting in 2008 with the targeting and the discrimination against minority home buyers in mortgage lending. And, you know, we talk about justice and equality, closing the wealth gap. We talk about diversity. But this is the kind of stuff that undermines all of that. It continues somehow to cause minority consumers to be in a position where they'll never be able to close the wealth gap, because at every turn in our society, whether we're looking at car lending or we're looking at mortgages or whether we're looking at payday loans or whether we're looking at any aspect of consumerism, we find that minorities consistently are targeted and discriminated against. Again, I really, really hate to have to continue to do this work at this point in my life because I just believe that our country should have gotten over this kind of discrimination by now and should understand the harm that is done to the very people that folks say should pull themselves up by the bootstrap. Every civil rights group supports me against this bill. Every consumer organization supports me against this legislation. And I want to tell you one other thing. Another thing is this. This is a classic example of the powerful interest group that says, I do not want, not regulations, but a simple guidance. And they come to the Congress of the United States and they mislead. I don't think everybody who's supporting this intends to discriminate, but I think oftentimes they're misled about what is being attempted by one of these industries. And so you have this powerful special interest group, our auto dealers. Now, the minority automobile dealers are against this bill. They said, even though we can make more money doing this, it's not right to do. And so this special interest and this powerful group is coming in here once again showing that they can own and control the Congress of the United States no matter the discrimination, no matter the harm that they're doing to minority communities. I thank you so much for allowing me to be here today. I just wish I didn't have to continue to do this kind of work to try and protect folks who are being discriminated against in our society. I yield back the balance of my time.
Ms. Waters, thank you very much. You know, I wish I didn't have to do this either. We just had a bill that was before us where we had a government organization, the NLRB, decided that they were going to do some things that were against 30 years' worth of case law, and they decided that government would just expand itself. This specifically is prohibited by law, a current law, a law that I did not vote for, a law that I don't like, but a law that was passed. And specifically, it stated that this CFPB would not be engaged in their business. They're now engaged in their business, no matter the reason. So, Mr. Chairman, car dealers, this industry, is it unregulated?
Well, absolutely not, Mr. Chairman.
Oh, okay.
And again, I don't like the work of having to protect Dodd-Frank, a law that, by and large, I think has done great harm. But there is a provision in Dodd-Frank. I didn't put it there, but there is a provision in Dodd-Frank that exempts auto dealers from the purview of CFPB. And frankly, I think that this is a government agency that is now using, frankly, a deceptive regulatory practice contrary to the provisions of Dodd-Frank to use the indirect lenders as a way to regulate the auto dealers who are already regulated through state attorney generals, through the Federal Trade Commission. They have to abide by every other non-discriminatory law throughout our nation. And I just don't know of a serious business person who has a business model that's successful that discriminates against consumers. You know, it's a serious accusation and it deserves serious attention, but instead what we have from the CFPB is they themselves admit that their own analysis is flawed. They themselves admit it could be flawed by as much as 20%. They don't have the data. And so all we're saying in this very bipartisan bill, again supported by between half and 2/3 of the Democratic members of the House Financial Services Committee, is that if you're going to essentially use guidance in place of rulemaking, at least do it with notice and public comment. Put your hand on the table. Let's really take a look at your own methodology, this Bayesian geocoding, and let's see if that stands up to public scrutiny. And by the way, you ought to be doing an analysis to figure out, quite possibly, are you hurting the very people you claim to be supporting? Because at least in one case where there was a settlement without any admission of liability between Honda and the CFPB, by trying to impose a flat rate, what Honda did was they increased their wholesale rate, which means particularly those who were of particularly good credit worthiness end up paying more. So again, we're not sure that the CFPB even has a leg to stand on with their flawed discriminatory analysis. And then if they do, they very well could be hurting the consumers they claim they're helping. And I guess to use, since I'm the father of a 12-year-old and a 13-year-old, and some of their phrasing ends up in my vocabulary, we're telling the CFPB it's time for a do-over.
Yep. Good. Well, and follow the law. Thank you very much. Chairman Cole?
No questions, but I thank the gentleman for bringing the bill. Look forward to supporting it.
Thank you very much. Mrs. Slaughter?
No questions, but I want to thank Ms. Waters for the fact that she does profoundly speak up for what I consider to be the right thing. I don't know any time we've had bills for discrimination again. Thank you, Ms. Waters.
You're welcome.
And thank you, Mr. President.
I told you all we're popular. Judge, I've told them earlier they're popular witnesses that we have here on a regular basis, and I'd like them to come
They're
here.
my good colleagues.
And they're our colleagues. Thank you very much. Judge Hastings, do you seek time? Thank you very much. Does any other member, the gentleman from Georgia is recognized.
Thank you, Mr. Chairman. Ms. Waters, I have tremendous respect for you and always learn something when you come up to testify. It fell heavy on my ears when it sounded like you said the only reason this bill was before us is because there are powerful special interests out there that are controlling of Congress. Did I misunderstand that? Or, again, I know you speak with great conviction. Is that the conviction that you hold?
Mr. Woodall, I thought about this a lot before I came to this committee today, and I knew that when I talked about this special interests and how powerful they are, that would not sit well with some members. None of us like to be thought of as folks who are unduly influenced by any special interest. But I decided, looking at what is happening with this legislation and the work that we've been doing to try and help people to understand, and working with all of the civil rights groups, that I was going to say it. And I was going to say it because it rings true for me. And yes, what I'm saying is you have a very special, powerful interest group, our automobile dealers, who have worked this Congress, and they are prevailing to this point because people who have, all of us, have automobile dealers in our districts, and they have made their wishes known. And they have decided that they were coming after the Consumer Financial Protection Bureau, and we have members who are not questioning them, who are not willing to talk about discrimination, not willing to talk about the fact that it has been proven that minorities have been charged more. The markups have been more. I mean, that information is before us. So yes, I've decided that I would take that step, and I would say to all of us, yes, they have unusual and powerful influence on this Congress.
Well, I bring good news for you today then, because I know many of the men and women who have co-sponsored this bill on both sides of the aisle, good Republican men and women, good Democratic men and women, who I can say without a shred of uncertainty are not remotely swayed by special interests and are persuaded only by the merits of their constituents' case back home. But it's my understanding, and I'd welcome the chairman to correct me, but it's my understanding that the only reason we're here is because when Democrats were running the House and Democrats were running the Senate and a Democrat was in the White House, Dodd-Frank was passed, signed into law with a special exception that said thou shalt not regulate the auto financing industry. I was not here then, but I would never suggest that the Democratic majority in the House, the Democratic majority in the Senate, and President Obama would have been callous about the needs of minorities facing discrimination and trying to get a leg up on the economic ladder, and would have been beholden to a powerful special interest and carved out a specific section of the law, knowing the bad effects that it would have in terms of upward mobility, simply to kowtow to a big donor. I would never suggest that that was the case. What explanation, what can you provide to me from that time before I arrived?
If I may, let me help you.
Please.
The same special interest, powerful interests that I'm talking about to you today, the same ones who had influence over that decision to get carved out. Why do you think there would be a special carve-out? It is not because the members of the conference committee sat there and said, oh, let's just carve out the automobile dealers. It's because they came in here the same way that they're coming in here now, and they influenced the members. I don't care if they were Democrat or Republican. They got influenced by the car dealers, and they got carved out because they yielded that kind of influence on this Congress.
I suppose.
I don't care if they're Democrats or
Oh,
Republicans.
I share your conviction that we need to do a better job of holding ourselves accountable on both sides of that. I have always attributed it to the fact that the driver of Dodd-Frank was a New York collapse, folks thinking Wall Street was taking advantage of Main Street, and I've never heard anyone suggest that the reason that the economy fell, that America's economy collapsed, was because too many car dealers were making too many car loans. And I thought it was because even with that great expansion of government that was going on during Dodd-Frank, that folks said, just to be clear, because we know the natural progression of government is to grow and expand, this was targeted at Wall Street banks. This is not targeted at Main Street car dealerships. And from the get-go, we wanted to make that clear. But I share Ms. Slaughter's appreciation for your convictions, and I do believe that we have better, that we make better policy when men and women of conviction come together to
Before you yield back, I just want to make sure that you know that CFPB do not regulate dealers, but they have explicit authority over lenders under Dodd-Frank. There was no enforcement of the Equal Credit Opportunity Act before we had CFPB that was organized. So this business about they have no business in this subject matter at all is not quite right.
Though again, on areas on which we will probably agree, to the degree that they have been given explicit authority to regulate anything, I don't think either of us would think that a couple of pages of guidance is the right way for an agency to handle something over which they've been given explicit regulatory authority. We would expect them to go through the normal rulemaking process. We would expect them to come out and take that job seriously. The conflict I have, knowing a lot of government folks as I do, if you're a regulator and you have responsibility of something, you come down hard and fast. If you're a regulator and you have no responsibility for something, but you want to stick your toe in the pool anyway, you start releasing guidance. That's not your experience.
No. Difference between guidance and regulation. As I said, they have the authority to regulate, to enforce Equal Credit Opportunity Act. And that's what they're acting under. And this is a guidance. And this business about, treat them like a regulation simply an opportunity to tie the hands of the Consumer Financial Protection Bureau. It's simply a guidance, and it's not a regulation.
Yeah, I thank the gentlelady. I thank the chairman. And, Mr. Chairman, I yield back.
Yes, sir. Gentleman yields back his time. The gentleman, Dr. Burgess.
Thank you, Mr. Chairman, and I'll thank both of our witnesses for being here. Chairman Hensling, I just have a general question because this concept of guidance is something with which I was not familiar until really just a few years ago, and it seems to crop up more and more, and it is a way for an agency to regulate without going through the Administrative Procedures Act, without putting things out there for public comment. And I don't, we're having a whole hearing on it tomorrow in Energy and Commerce on guidance issued by the Food and Drug Administration regulating, except they're not regulating, it's only guidance on laboratory-developed tests, and yet it invokes a whole new scheme that has to be adhered to and followed, but it's guidance. No one's ever commented on it. So adhering to that quaint romantic notion that we have government only with the consent of the governed, guidance doesn't seem like the best way to go about it. We should follow the law. We should follow the rules. And that's, Mr. Chairman, my observation. Thank both of our witnesses for being here today.
Thank you very much, Dr. Burgess. Does any other Republican or Democrat seek time? No member of the committee seeking time. I want to thank both of you for taking time for your frankness with the committee, coming and speaking your mind, and most importantly, to updating us on the important legislation that we'll be moving forward with. And I want to thank both of you. Please remember, anything you have in writing that you leave for our awesome stenographer, I appreciate it very much. And I want to thank you both very, very much.
Thank you very much, Mr. Chairman. I
bet.
appreciate you.
Thank you very
Thank
much.
you. Thank
We've had two important friends of mine walk in the room. The gentleman from Dallas, Texas, Chairman Roy Bailey. Mr. Bailey, we're delighted that you're here with your Mr. SMU. We also have your son, Billy Bailey, from the University of Alabama. I appreciate you taking time to be with us today. We are now going to attempt to finish off the paperwork. And so we're going to be in recess until right at 6:20. It's about 6:05 or 6:06 right now, which means that we're going to finish our paperwork, come back in at 6:20. So pending that, committee will be in recess until 6:20 p.m. Pretty close.
Louise was the one who was far away. I think I ran into.
Rules Committee to come to order, and thank you very much for coming back with us. Now 6:20. We're going to get started. Virginia, you got some friends here.
I do. They're from my district. They're three young people who've been with me practically all day long.
That's awesome. Well, welcome to the Rules Committee. We're delighted all three of you are here. We're going to see if we can show you how Mrs. Fox chooses to get things done. Now watch this. The gentlewoman from Grandfather Community, North Carolina, the gentlewoman, the vice chairman of the committee, Mrs. Fox, is recognized.
Thank you, Mr. Chairman. I move the committee grant H.R. 1737, the Reforming CFPB Indirect Auto Financing Guidance Act structured rule. The rule provides 1 hour general debate equally divided and controlled by the chair, ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only those amendments to H.R. 1737 printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 511, Tribal Labor Sovereignty Act of 2015. Under a closed rule, the rule provides 1 hour debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and the Workforce. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Education and the Workforce now printed in the bill shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions for the purposes of requesting a conference with the Senate. Section 3 of the rule provides that the House has taken S. 1177, the Every Child Achieves Act of 2015, from the Speaker's table, adopts an amendment in the nature of a substitute consisting of the text of H.R. 5 as passed by the House, and adopts S. 1177 as amended. The rule provides that the chair of the Committee on Education and Workforce or his designee is authorized to move that the House insist on its amendment to S. 1177 and request a conference with the Senate thereon. Finally, Section 4 of the rule provides that in the engrossment of H.R. 3762, the clerk shall strike Title I and redesignate the subsequent titles accordingly.
Thank you very much. You've heard the motion by the gentlewoman from North Carolina. I would defer to the gentleman from Oklahoma for discussion of the bill. The gentleman is recognized.
The Rules Committee will meet tomorrow at 3 to consider the other two financial services bill for the week. This rule provides for consideration of H.R. 1737 under a structured amendment process and H.R. 511 under a closed rule. The rule for the auto financing bill makes in order all the germane amendments submitted to the committee. The rule also facilitates getting into conference on the Elementary and Secondary Education Act reauthorization. Lastly, the rule directs the clerk to strike a provision from the reconciliation bill, which was already enacted into law in the Bipartisan Budget Act of 2015, facilitating consideration of the bill by the Senate. It's a fair rule, Mr. Chairman, deserves support of all members.
Chairman Cole, thank you very much for discussion of the rule. We're now open to amendment or discussion.
Thank you, Mr. Chairman. I have an amendment to the rule.
Gentlewoman's recognized.
I move the committee grant H.R. 511 and H.R. 1737 each open rules so that all members have the opportunity to offer amendments to the bills on the floor.
Thank you very much. In support of the rule that we're writing here, this was a very narrowly constructed piece of legislation on the tribal issues and the auto lending. We made in order those amendments that were germane, and I feel like it's a good way to do business this week and further discussion.
I have no further discussion.
Seeing none, the vote will now be on slaughter amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
And those have noes. Gentlewoman asked for a roll call vote.
Ms. Fox?
No.
Ms. Fox? No. Mr. Cole? No. Mr. Cole, no. Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? No. Mr. Stivers, no. Mr. Collins? No. Mr. Collins, no. Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? No. Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 9 nays.
The amendment's not agreed to for the amendment or discussion.
I believe not.
Seeing none, the vote will now be on the motion from the gentlewoman from Grandfather Community, North Carolina. Those in favor signify by saying aye. Those opposed, no.
No.
Ayes have it, ayes have it. And this accordingly will be handled by the gentleman, the chairman from Oklahoma, Mr. Cole.
And I will handle for the
And Mrs.
Democrats.
Slaughter will handle that for Democrats. I want to once again thank our 3 expert, beautiful students from North Carolina for taking time to be with your favorite Congresswoman, Mrs. Fox. I want to thank the gentleman, Mr. Bailey, and Bill Bailey from Dallas, Texas, my dear friends, and the gentleman from Colorado is recognized.
Mr. Chairman, without objection, I'd like to submit some further comments by Mr. Scott into the record.
Without objection. This appears to be our work for the day. However, as Chairman Cole noted, the Rules Committee will meet tomorrow at 3 o'clock p.m. to consider 2 financial services bills. So it looks like that we'll be getting 2 of our favorite witnesses, Chairman Henserling, as well as, well, I think he's one of our favorite witnesses, as well as Mrs. Waters, who's one of my favorite witnesses. So we'll share that. And I want to thank each of you for being here. Welcome back home. Like your haircut, kid. You like mine?
It's just not me.
Yeah, how about my haircut? You like
I
mine?
think it's sharp as a tack.
Yeah, well, we're going to find out tonight when Karen sees me what it looks like. There you go. We're done with our work. Thank you very much.